16 interruptions. 9 minutes. One question she could not answer. That is the arithmetic of what happened inside House Judiciary Committee Room 2141, when Congressman Jamie Raskin sat down across from Attorney General Pam Bondi and decided that today was not a day for political theatre. Today was a day for constitutional reckoning, and by the end of it, the most powerful law enforcement official in the United States of America sat in silence, mouth open, no words coming out, while a former constitutional law professor looked at her and said 4 words that will define this moment for years. You have no choice. Stay with me until the end of this video. Because what Raskin forced Bondi to reveal, not through shouting, not through grandstanding, but through methodical, relentless, surgically precise questioning, will fundamentally change the way you understand what is happening with the Epstein files, and who is working very hard to make sure you never see them. Let me set the scene properly, because context matters here. The House Judiciary Committee had been in session for roughly 40 minutes before Raskin took the microphone. In those 40 minutes, Bondi had performed her usual routine with practiced ease. Measured responses, carefully constructed non-answers. The kind of testimony that sounds substantial in the moment and contains absolutely nothing when you examine it afterward. She had handled 8 different questioners with the relaxed confidence of someone who has navigated difficult rooms before and always found the exit. She arrived with 3 attorneys and 2 senior aides. She sat at the witness table with the body language of someone who considers this a minor inconvenience scheduled between more important meetings. She checked the time twice in the first 20 minutes. She was not worried. She should have been. For those who do not know Jamie Raskin's background, it is worth understanding before we go any further. Because his background is precisely why what happened next unfolded the way it did. Maryland's 8th Congressional District. Harvard Law School. 25 years teaching constitutional law at American University. Lead impeachment manager for the second Trump trial, where he constructed a legal argument so airtight that even members of the opposing party privately acknowledged its rigor. Raskin is not a politician who dabbles in law. He is a legal scholar who entered politics. That distinction matters enormously in a congressional hearing, because most witnesses are prepared for politicians. They are not prepared for someone who spent a quarter century teaching other people exactly how law works, where it breaks down, and how to expose the difference between genuine justification and procedural cover. When Raskin took the microphone, the room adjusted. Not dramatically, subtly. The kind of shift that experienced observers recognize. Cameras that had been stationary, repositioned. Journalists who had been typing notes put their pens down and looked up. Even Bondi's legal team, people paid specifically to anticipate threats, sat forward in their chairs. The first exchange happened fast. Raskin stated his subject. 47 names appearing in the Epstein investigation files that the Department of Justice had blocked from public release, despite completed reviews recommending disclosure. He did not finish his second sentence. Bondi cut him off. Standard response. The department does not comment on ongoing investigations or sensitive materials that. Raskin did not raise his voice. He simply redirected. These are not ongoing investigations. These are closed files. Files that completed the FOIA review process. Files that 5 senior DOJ officials, including career prosecutors with no political agenda, reviewed and cleared for release with appropriate redactions. Files that you personally ordered, sealed 3 weeks after taking office. I am not asking about open cases. I am asking about a decision you made, in writing, to reverse your own department's recommendation. Why? Second interruption arrived before he finished. Bondi claimed his characterization of her directive was inaccurate. Raskin held up a single sheet of paper. Read the room. Everyone in that chamber could see the document from where they sat. This directive, he said, dated and signed, designates all materials related to a specific investigation as law enforcement sensitive and exempt from public release. He read the exact language. Then he paused. There is no mention of victim protection in this document. There is no reference to sensitive sources. There is no stated justification of any kind. It is a blanket seal. Signed by you. Third interruption. Bondi said the directive was developed in consultation with career prosecutors. Raskin's response was immediate. I did not ask who you consulted. I asked why you reversed a conclusion that those same career prosecutors had already reached. Because here is what is interesting. The career prosecutors you claim to have consulted in March had already concluded in February that these materials could be released. So either you consulted different career prosecutors, or the same career prosecutors reversed their position after you took office. Which is it? This is where the hearing began to turn into something different. Because Raskin then produced a second document, an internal Department of Justice memorandum dated several weeks before Bondi's sealing directive. An assistant United States attorney had written, clearly and without qualification, that the materials in question had been reviewed by classification specialists, by privacy officers, and by senior counsel. The conclusion was unanimous. The 47 names could be released with appropriate redactions. Release was recommended. 5 officials. 1 conclusion. Release. Bondi overruled all of them within weeks of taking office. No public explanation. No counter-memo on record. No documented justification that contradicted the professional recommendation she was overriding. Raskin set the paper down and asked the only question that mattered. Why? Fourth interruption. Fifth. Bondi pivoted to national security. There were implications she could not discuss in an open setting. Sensitivities that required a different forum. Raskin did not blink. He offered to go into closed session immediately. He offered to clear the room. He offered to move the entire line of questioning into a classified briefing where genuine national security concerns could be addressed properly. Unless, he said, and his voice stayed completely level, you are indicating that there are no actual national security concerns. And you are using that phrase as a procedural mechanism to avoid answering. That micro-expression. If you watch the footage, it crosses her face in less than a second. The recognition that the exit she was moving toward had just been blocked. Then he produced the third document. A memorandum from the Director of National Intelligence, dated 2 days before Bondi's sealing directive. The DNI's office had reviewed the materials independently. Their conclusion: no classified information. No intelligence sources or methods at risk. No national security basis for withholding. Public release would not compromise any active intelligence equities. The Director of National Intelligence said there was no national security concern. Bondi issued a sealing Directive 40 8 hours later, citing, implicitly, national security. Raskin laid it out without editorial comment. The DNI says there is no national security issue. That means the justification you implied does not exist. So what is the actual justification? I am asking you directly, under oath, with documentation in front of us. What is it? Interruptions 6, 7, and 8 came fast, overlapping, losing coherence. Bondi was no longer operating from a script, she was improvising. And when people who rely on prepared responses are forced to improvise, the seams show. Raskin waited each time. Let her finish. Did not compete with her for airspace. Simply returned to the same point with the same calm. The question is still there. What is your justification? And then came the moment that defined everything. Raskin stood up slowly. Not dramatically, just deliberately. He picked up a small book from the table beside him. Held it up so the entire chamber could see it clearly. The United States Constitution. The room went quiet in a way that committee rooms almost never go quiet. He did not raise his voice. If anything, he brought it down. He spoke with the measured cadence of someone who has explained foundational legal concepts to students for 2.5 decades and knows exactly how to make something land. He said, I have spent 30 years with this document, teaching it, arguing it, prosecuting cases built on it. And I can tell you with complete certainty that nothing in these pages grants any executive official the authority to withhold public records from congressional oversight without documented justification. Nothing in here allows a cabinet member to override professional recommendations from her own department without accounting for that decision. And nothing in here exempts anyone from answering a direct question, asked under oath, by a duly elected representative of the American people. He set the book down. He said, "Here is what is going to happen. I am going to ask my question, one final time. You are going to answer it. If you attempt to interrupt me before I finish, I will move for a contempt finding, and we will resolve this in federal court. Do we understand each other?" The silence that followed was not a pause. It was a collapse of all the ambient noise that fills rooms like that. No shuffling, no whispers, no background movement. Even the building seemed to hold still. Raskin adjusted his microphone, asked his question. "Who directed you to seal the 47 names in the Epstein files?" Interruption 15 began forming. Started. Stopped. Bondi looked at her legal team. Both lawyers were writing. Neither looked up. She was alone with the question and the oath she had taken before sitting down. And then Raskin said it. "You have no choice." Not loudly. Not as a threat. As a statement of plain fact, delivered by someone who has spent a career understanding exactly what legal obligation looks like, and exactly when it applies. You have no choice. You are under oath. You are subject to a valid congressional subpoena. You represent a department that exists to enforce the law. And I am asking you a question that the law requires you to answer. Who told you to seal those files? What followed was not defiance. It was collapse in slow motion. Bondi's voice, when she finally produced words, was barely carrying across the table. She could not provide an answer in the current setting. Raskin noted the specific language immediately. Not that she did not know. Not that no such person existed. Not that she was unaware of any directive. She could not provide the answer in this setting. Which means the answer exists. Which means she knows it. Which means she is choosing, in this moment, under oath not to say it. He gave her every available legal exit. Executive privilege. Attorney-client privilege. Fifth Amendment protection. She took none of them. Her lead attorney stood and requested time for consultation. Raskin looked through him as if he were not there and spoke directly to Bondi. "Your counsel can advise you on privilege claims. He cannot advise you to simply not answer. You either have a legal basis for silence or you do not. Which is it?" Bondi did not answer. What Raskin did next was the most strategically significant part of the entire exchange, and it is the part that most coverage has missed. He did not press for a dramatic confession. He did not escalate into accusation. He picked up his documents methodically, organized them, and entered them formally into the congressional record. Every memo, every cleared recommendation, every directive, every piece of paper establishing that the 47 names were reviewed, cleared, and scheduled for release before someone made a phone call or sent an email or walked into an office and changed that outcome. He said, "These are now part of the permanent record. And tomorrow, I am filing a motion to compel your testimony in closed session, under the full weight of perjury statute, where you will answer this question or face consequences that are not procedural, but criminal." Then he stepped back from the microphone, yielded his remaining time, sat down. The hearing continued for another hour. Technically. Other representatives asked other questions. Bondi gave other non-answers. The committee's formal business proceeded. But the room had already moved on. Because everyone present understood that something had broken open in those 9 minutes that could not be resealed by procedural continuity. Within the hour, clips were circulating across every platform. Not the confrontational moments, which is what usually spreads from hearings. The quiet moments. Raskin holding up the Constitution. Raskin's voice dropping as he said, "You have no choice." The silence that followed. Bondi's hands flat on the table. Her lawyers frozen. Legal scholars began analysing the contempt implications. Constitutional law professors were being contacted for commentary. Congressional historians were being asked whether a sitting attorney general had ever been placed in a comparable position in a public hearing. And somewhere in the city, whoever made the phone call that resulted in 47 names being sealed was calculating how much time remained before Raskin's closed session. Motion produced a setting where the answer could no longer be avoided. Here is what I need you to understand about why this moment is larger than one hearing. Congressional oversight hearings happen constantly. Cabinet officials testify constantly. Evasion is the norm. Deflection is standard. The machinery of non-accountability operates so smoothly and so consistently that most of the public has stopped expecting anything different. What Raskin did was not simply ask better questions. He constructed a documentary record in real time, in front of cameras, that made evasion architecturally impossible. Each document he produced was not just evidence for that moment. It was a brick in a structure that is now permanently in the congressional record and cannot be removed, amended, or reclassified by executive action. He did not need her to confess in the chamber. He needed to establish, irrefutably, that a professional recommendation was overruled, that the stated justifications do not exist in the documentary record, that the official responsible for the overruling cannot provide a legal basis for it under oath. That is now established. That cannot be unestablished. The contempt motion that follows, the closed session testimony that follows that, the legal challenges that follow all of it, those are battles that will be fought with O. Foundation already in place. A foundation Raskin spent 9 minutes building while Bondi interrupted him 16 times and thought she was winning. There is a principle in constitutional law, one Raskin has taught for decades, that institutional power is only as durable as the accountability structures surrounding it. Remove accountability, and power does not simply become more powerful, it becomes more fragile. Because unchecked power accumulates enemies and leaves trails. And the trails, once found, do not disappear. The 47 names connected to Jeffrey Epstein's operation are not an abstraction. They represent a documented network of individuals whose connection to a federal sex trafficking case has been officially acknowledged and officially buried. The people connected to those names are not unknown to investigators. They are known, documented, and protected by decisions made in offices that are supposed to serve the public. What Raskin exposed in that room is not just that the protection is happening. It is that the protection requires active, ongoing effort. It requires directives. It requires overruled recommendations. It requires officials sitting under oath and choosing silence over accountability. That is not the behavior of a secret that simply has not been found. That is the behavior of a secret that is being maintained. Actively. Continuously. At significant legal and institutional cost. Secrets that require that much maintenance do not stay secret. The pressure builds. The maintenance becomes more difficult. The people responsible for the maintenance start calculating their own exposure against their loyalty to whoever they are protecting. And when that calculation tips, everything comes out at once. The question this moment leaves you with is not whether those 47 names will eventually become public. Based on the legal machinery now in motion, the probability of permanent suppression is declining. The question is what comes after disclosure. Because information about networks like this does not exist in isolation. It connects. It extends. It implicates people and institutions far beyond the individuals whose names appear on a list. And the political, legal, and social consequences of that connection becoming visible operate across timeframes that are not measured in news cycles. We are at the beginning of that process. Not the middle. Not near the end. The beginning. What Raskin did in 9 minutes was not close a chapter. He opened one. He built a legal foundation in public, on camera, in the permanent record that will support everything that comes next. And he did it without a single raised voice, without a moment of theatrical outrage, without any tool except preparation, documentation, and an absolute refusal to accept. Procedural evasion as a substitute for accountability. 4 words that stopped a room. You have no choice. And the reason those 4 words landed the way they did is because they were not a threat. They were a description of reality. The law creates obligations. Oath creates obligations. The documentary record Raskin, assembled in front of that committee, creates obligations. Bondi has no procedural exit left that does not create a larger legal problem than the one she is trying to avoid. That is not a political outcome. That is a legal outcome. And legal outcomes operate on schedules that political maneuvering cannot indefinitely delay. The next hearing will start from this moment. The next document request will reference this record. The next contempt motion will build on this foundation. The silence in that room after Raskin sat down was not the silence of an ending. It was the silence of something beginning. Share this. The story is not finished. And when the next piece of it surfaces, you will want to already understand how we got here. Subscribe. Turn on notifications. Because this conversation is not going anywhere except forward. And forward is exactly where accountability eventually leads.